What are new conditions on real estate purchase and sale in 2022? Real estate business activities have a great influence on socio-economic development. Accordingly, in order to ensure the legal framework for the current real estate business activities, the government has issued Decree 02/2022/NDCP detailing the implementation of a number of articles of the law on real estate business, Decree 02/2022/NDCP, in order to promptly amend and supplement inadequate regulations to be consistent with reality. In which, conditions for the transfer of contracts of purchase and sale, lease purchase of houses and construction works are mentioned. Therefore, there is no legal basis to carry out these transactions in reality. Therefore, Decree 02/2022/NDCP has had a number of amendments and supplements and has overcome some limitations compared to the past, which is expected to solve problems and inadequacies. Accordingly, Decree 02/2022/NDCP has combined conditions for transfer of contracts for purchase and sale of future houses and conditions for transfer of lease purchase contracts for existing houses and construction works with specific regulations. Firstly, the transfer of the contract requires a purchase and sale contract or a lease purchase contract made in accordance with regulations. Accordingly, these contracts must ensure compliance with the provisions of the transfer agreement form for each transferred real estate object, whether it is a contract for sale, purchase, lease, and purchase of an apartment, or tourist apartments, condotel, office apartments combined with accommodation, officetel, are valid and allowed to be used for transfer. In addition, for cases where the parties have signed a contract before the effective date of Decree 02/2022/NDCP, the signed contract must be present. Therefore, when transferring these types of contracts, the parties should pay attention to ensure the legality of the respective contract in terms of form and time of establishment. Secondly, the transfer contract must be in the category that has not yet submitted a dossier to request a competent state agency to issue a certificate of land use rights, ownership of houses and other land-attached assets. This provision has been mentioned in the previous regulations for the transfer of real estate contracts formed in the future. Up to now, this is still a necessary regulation to ensure that the handling of licensing procedures does not overlap, eliminating the risk that a real estate bears two or more certificates for the same object. Accordingly, the disputed contract will not be used to transfer to a third party. This provision is consistent with the provisions on prohibition of transferring property rights to the disputed property. Therefore, in order to transfer the contract, the parties need to settle the dispute in advance to have a basis for the transfer of the contract. In many complicated cases, the real estate dispute lawyers need to be consulted for proper dispute solutions. Fourthly, houses and construction works that are the subject of purchase and sale or lease purchase contracts must not be subject to distraint or mortgage to secure the performance of obligations as prescribed by law. Recently, the phenomenon of transferring these contracts has increased which seriously violated the provisions of the law, making it difficult for relevant competent authority to handle, otherwise causing damages to the transferee without understanding the legal issues for the transferor in the contract. However, with the principle of respecting the agreement of the parties, the law still allows the assignment of the contract in this case if the mortgagee agrees, and this consent must be recorded specifically to avoid disputes later. It can be seen that the highlight of Decree 02/2022/NDCP has initially solved the inadequacies in the transfer contract for tourist apartments, condotel, office apartments, officetel, that help relevant competent authority have a legal basis to handle the requirements.